Hello, everyone. We can just give a couple more minutes for people to join. All right, let's get started. So thank you everyone for joining. This is one of our monthly SALDEF Speaks webinars, and we're really excited to have it this month. My name is Saiba. I am the Media Relations Manager at SALDEF, and we're really excited for y'all to be here today. This month's webinar is going to be on the Supreme Court nomination hearings on Judge Ketanji Jackson, her record, why Sikh Americans should care about her nomination, why Sikh Americans should care about the Supreme Court processes. And we're just so excited here to talk to you today. We have a great set of panelists here. We have Dave Sidhu, who is a criminal defense attorney. We also have Tejinder Singh here, who is another attorney with us. And we're going to talk about what all you need to know about the Supreme Court and why it matters. So we're really excited here to talk to you today. We also want to show support to the Biden administration for nominating such a qualified candidate for the Supreme Court. And if confirmed, Judge Jackson's nomination would be a historic first. She would be the first Black woman to be confirmed in a justice on the Supreme Court. We also have our amazing host, Rajveer Gumer, and we're very excited for this panel and this discussion. Additionally, we also wrote and published an op-ed on Brown Girl magazine, and the op-ed is our support to Judge Jackson, and we would love for you all to share and share with your networks so we can get more traction on it. But the op-ed is about why the Supreme Court nominee Judge Jackson matters to Sikhs, especially Sikh women, how it empowers Sikh women, and how we can create our own identity within the Sikh fabric and the Sikh American fabric, and also the American political fabric. I'll be dropping the link to the op-ed in the chat so you guys can read it and share it with your networks. So without further ado, I'm going to pass it over to Rajveer so he can start the great discussions we're going to have today. So Rajveer, you can also just give a brief intro to our panelists again if you want to, but I'm going to pass it over to you. You're on mute, Rajveer.
Good catch. Thanks, Saiba. So I'll give a brief background on each of our panelists because they definitely have an amazing background that I think should be appreciated. So Tejinder Singh is a partner at Sparacino PLC, where he is a go-to advocate for plaintiffs, including whistleblowers and also victims of terrorist attacks, air crashes, pharmaceutical product defects, and civil rights violations. Before joining Sparacino PLC, Tejinder was a partner at the elite Supreme Court appellate litigation boutique, Goldstein and Russell PC, where he made history as the first turban Sikh to ever argue a case before the Supreme Court of the United States, and also served as counsel of record in dozens of cases in the Supreme Court and appellate courts. Through more than a decade of experience presenting arguments to the most demanding judges in opposition to the best lawyers the defense bar has to offer, Tejinder has developed a deep understanding of the law, including an ability to anticipate trends and shape them through skilled advocacy. Supreme Court Justice Elena Kagan recently described him as an awesome lawyer, and his co-counsel in several high-stakes cases commented that Tejinder's advocacy transformed our trial court and appellate briefings into some of the best exemplars of written advocacy I've ever had the privilege of signing, and that Tejinder is the best oralist I have known, with the ability to change an obviously hostile judge's mind at argument. Outside of his legal practice, Tejinder makes frequent panel appearances to discuss legal developments and also serves on the President's Council of Taxpayers Against Fraud, the advisory board of the Federal Bar Association's Qui-Tam section, and the board of directors of SE Justice Group and the board of trustees of Concord Hill School. For several years, he has taught Supreme Court litigation at Harvard Law School. So just wanted to welcome Tejinder here. Thank you for you appearing here. So Devinder Dave Sidhu is an attorney, public servant, and academic. He works at a boutique criminal defense firm and previously served as a Supreme Court fellow at the U.S. Sentencing Commission, special assistant to the chair of the commission, staff attorney in the U.S. Department of Education's Office for Civil Rights, and law clerk to the U.S. District Judge David G. Campbell. In addition, Dave has also held teaching appointments at Georgetown University Law Center, University of Baltimore School of Law, University of Maryland Francis King Carey School of Law, and University of New Mexico School of Law, where he became the first Sikh to receive tenure at a U.S. law school. He was an elected term member in the Council of Foreign Relations, sits on the Gucci Changemakers Council, volunteers with his local fire department, and founded an outpatient addiction facility in his hometown. Born and raised in Maryland, Dave earned degrees from the University of Pennsylvania, Johns Hopkins University, and George Washington University, as well as certificates from the U.S. Army War College and Northwestern University. Welcome, Dave. So I'll get right into it. So this discussion is going to kind of fit the entire community of the basic understanding to the in-depth understanding. So we're going to start out on the basic level, and Tejinder and Dave are going to start there, and then we're going to work into more in-depth discussion. So the first question I have is, we have three branches of government. We have the executive, which is the president and the federal agencies. We have the legislative, which is Congress, and we have the judicial branches. The judicial branch includes the court system and the Supreme Court. Tejinder and Dave, could you explain the role of the Supreme Court and judicial branch, the structure of the Supreme Court, and also its jurisdiction? So I'm giving you a lot of parts to that, but I'll let you guys run with it. Whoever wants to step up, go for it.
I can take a stab at that one. First, I want to commend SALDEF for convening this important and very timely conversation. I also want to pay tribute to my co-panelist, Tejinder Singh, who is a brilliant advocate in general, and as was mentioned in the intro, was the first Sardar to ever argue before the Supreme Court. I happened to be in the courtroom when he made that first argument, and I was very delighted to observe and witness such a historic moment. So I just wanted to, at the outset, pay my respects and tribute to Tejinder for that historic advocacy. So the question here is, what is the Supreme Court? How does it fit? When I used to teach constitutional law, I used to think about questions of this sort in three different buckets. So first, what is the structure? Two, what are the respective powers? And three, what are the relationships between the components of our government? So first, structure, and the question already sort of addressed this. Article 1 of the Constitution deals with Congress, Article 2, the presidency, Article 3, the court system, the judicial power. And the judicial power shall be vested in any Supreme Court and any lower courts that Congress shall establish. So the Supreme Court has to exist by virtue of the Constitution, and Congress has utilized that authority to establish lower courts. So the Supreme Court sits in the Article 3 branch, that's the structure. Power, so what does it do? And the judicial power is the power of judicial review, which is to give a final and binding interpretation on the Constitution, on any statutes, on any regulations. And so what are the relationships? As a consequence of giving those binding and final interpretations, the Supreme Court can say to the other branches and to the states, what you have done is inconsistent with the Constitution and therefore invalid. So let's say, for example, Congress enacts a statute and says we're doing so pursuant to this authority, and the Supreme Court says, well, actually, we don't think you have that authority, then Congress has to go back to the drawing board. So the effect of a Supreme Court decision can be to invalidate that of another coordinate branch or that of a state. So that's effectively what the Supreme Court does, is review and interpret constitutional provisions and give final and binding interpretations to it. There's a question about jurisdiction. So there's really two buckets of jurisdiction. One is the bulk of what the Supreme Court hears, which is appellate jurisdiction. So as I mentioned, there's lower courts that Congress has established. The traditional path is that a case will go to a district court, a trial court. A party can appeal to an intermediate appeals court as a matter of right. And then if the losing party wants to take it to the Supreme Court has the discretion to decide whether or not to take a case. And so that's sort of the appellate jurisdiction. That's the vast majority of cases that come before the court. The second bucket is what we call original jurisdiction, where you can go directly to the Supreme Court. And the Constitution provides very limited bases for the opportunity for someone to go directly to the Supreme Court. A common example is if two states are suing one another, you don't have to go through the lower court process. You can proceed directly to the Supreme Court. Hope that's responsive, and my co-panelists can correct me.
Nothing to correct.
Or add to.
I guess one thing that I would add, the reason this matters, that the Supreme Court gets to pick and choose its cases, is it really makes it very important who sits on the Supreme Court, because they're doing, in addition to what lower court judges are doing, Supreme Court justices are agenda setting. They are deciding not only the outcome of the cases in front of them, but which cases to take up. And so sometimes you'll hear about people talking about the Supreme Court in the media, for example, and they'll be like, oh, the court decided half of its cases unanimously, you know, isn't that so great? Doesn't that mean they agree about everything? But that's largely a function of how they pick and choose their cases. And then there will be the cases that are more controversial. And so as you pay attention to who is on the Supreme Court and why it matters, one thing to bear in mind is who's on the court really affects what kind of cases go up. It affects who wants to take cases up, and it affects what kinds of cases actually get decided. And so it makes a big difference in terms of what the court's docket looks like. And then just to build a little bit on Dave's point about the docket, as he says, the Supreme Court is a co-equal branch of the government. It can wag the finger at another branch and say, no, you can't do that. And so when there is an ideological difference between the prevailing number of Supreme Court justices and the prevailing political parties, that's when you see the most conflict between the branches, and when who is on the Supreme Court can really matter, because it can really kind of gum up the works of government. Or vice versa, if there's alignment, you can see governments getting more aggressive. And so there's this system of checks and balances, and that's part of the reason why the court plays such an important function in the government, is that the justices are on for a really, really long time. Now, the average tenure is going to be more than 30 years probably. And so they survive through multiple administrations of multiple political parties and have a chance to exercise this role in very different ways.
Yeah, just to piggyback on that, so there are 9 justices on the court, and each one might have particular issues or concerns that are very important to them. And so when they have a petition or a request for a case, they might be looking for very specific issues. And so if you have a replacement, you might have a replacement not only of a justice, but a universe of issues that new justice cares about. And at the same time, there are circumstances in which there's a sense among practitioners that a certain justice might be blocking review of a particular type of case. I'm working on one right now where there's a sense that Justice Breyer maybe is not as receptive to our position. So we're trying to hold off on filing this request for his successor to get named, and maybe that successor would be more receptive. So when you just have 9 people, and all it takes is 4 to agree that yes, we should take the case, each individual justice matters that much more.
And yeah, that's actually an interesting point. So for those who don't know about the Supreme Court's and how its process works, normally you need a majority to decide a case. 5 justices have to agree what the right result is, but it only takes 4 votes to hear a case, which is interesting. Now, it is seldom the case, I think, that 4 votes go up by people who think they're going to lose. That their side is not going to be the prevailing side. 4 justices who are unlikely to walk into a buzzsaw on purpose. So normally when you see votes to grant cases, it often involves more than 4 votes, but they don't publish those votes. The information doesn't become public until, maybe a justice passes away and makes their papers public years after that. So it's very, very hard to know what the court is doing behind the scenes about when it hears cases or doesn't hear cases. That all happens in the background, but it only takes 4 votes. And that is really important because any justice can put a case on the list for the whole court to talk about and for them to think about it. And so again, this just goes to the point of why it matters who's on there.
Great. Awesome discussion, guys. So I'm just that kind of leads us to the next one is we've talked about those 9 justices, but what's the difference? I think everybody in our community is probably, and hopefully not, had interactions with a judge. Can you guys explain the difference between what a judge and a justice is, what the role is? How are they different from a standard judge that you might interact with in the lower courts?
Sure. So the major difference in function really comes from what we were just talking about, which is agenda setting. So as Dave said before in describing how the court system works, if you want to sue somebody, you can go to a federal district court and file a lawsuit. And then whoever loses that lawsuit, they can appeal. They have that right no matter what. And the appellate court has to hear the case. Those judges have no ability to turn a case away. They can say the case has no merit, or maybe they don't have jurisdiction or something, but in general, they don't have the right to say, we're not going to touch this, not our problem. The Supreme Court has that right. The justices have that power. And what follows from that is it really changes the function that they're trying to play. The Supreme Court is not mostly a court that cares about error correction. That is, if you're trying to get the Supreme Court to hear your case, and all you say is the decision below was really, really, really wrong, you're unlikely to get them to hear your case. Their official position on that is, yeah, we don't really care. If your case was right or your case was wrong, whatever, not really our problem. What they care about is deciding questions that are really important on sort of a nationwide level. And what they care about the most are 2 specific scenarios. Number one is where there's a conflict among the lower courts. So the lower courts are divided up geographically. And if one set of courts over here in New Jersey and Delaware is deciding a federal question one way, but courts in California and Nevada are deciding it another way, and it's going up through the systems and there's these conflicting precedents, the Supreme Court cares a lot about resolving those and getting to uniformity. And if you think about how federal law works, this makes perfect sense, right? You can't have one federal statute or one federal constitution mean one thing in California and a different thing in New Jersey. It would be nonsensical, the equivalent of not having a federal government at all. And so the Supreme Court's principal job is to impose uniformity when disuniformity arises. The second thing that they do a lot is if a lower court ever strikes down a federal statute, the Supreme Court will pretty much always hear that case because they have the view that the lower courts don't get to just do that on their own. When a co-equal branch of government, Congress, has tried to do something and the president has signed it into law, only the Supreme Court can definitively say that that's unconstitutional. So those are the 2 kinds of major things that the Supreme Court has its eye on. And that's very, very, very different from regular judges, because regular judges are basically just trying to decide the cases in front of them as efficiently as possible. And actually a really good way to understand this is to just know for a moment what the workload for different judges is like. And so in the district courts, judges are getting absolutely crushed right now. Every single district court judge will have hundreds of cases in front of them on all kinds of issues. And their job is really just to move their dockets along and try to get these cases toward resolution. The appellate courts, the judges will often have something like maybe at least 200 to 300 cases per judge cycling through at any given time. It varies by circuit. Some circuits are much quieter than others, but most of the bigger ones, it's like hundreds of cases per judge per year. And so each judge has to decide the equivalent of like a dozen cases a day just to keep up with the docket. The Supreme Court usually decides about 70 cases a year, right? So it's these 9 judges, but they're only deciding like 70 cases. And so they're being really selective and really focusing on the most important cases, which is just so different from the other courts.
Awesome,
Yeah,
thank you. Oh,
yeah,
Dave, you want to keep going?
yeah. The only thing I'll add is where you sit in the system pretty much dictates your role within that system and what your day-to-day looks like. So I used to work at the trial court level, which is kind of like doing triage. Anyone can come to court and file their case. And so the nature of that sort of work is just dealing with motions, someone wanting to kick out a case or say that something should enter evidence, and just dealing with trials. I mean, it's much more, um, it's much different, that the volume is so heavy that all you're doing is just trying to respond to those particular cases, and you have no choice. Whatever comes to your courthouse, you have to deal with. You know, the appeals courts, the next level, those folks sit in panels of 3. They will, things are a little slower at that point because things are much more reliant on the briefs that are filed, and then they might schedule oral arguments. So things are really on a different rhythm at the appeals court, and the appeals court, their ruling will be binding on the geography within it sits, that it sits within. So if you're, let's say in, you know, the 10th Circuit, your ruling is going to be binding on only certain federal district courts within that geographic area. So you want to say something that's going to be helpful and accessible to those lower courts, so that when they have future cases, they can then turn to that appellate court decision as sort of guidance. When you get up to the Supreme Court, their vantage point is much larger. They're looking at how can we provide guidance on a national basis to every single court that has to listen to what we have to say. And the rhythm there it's much different. They try to, they hear cases starting in the first Monday of October, and they try to complete all their merits rulings by the end of June. And then they're effectively off to engage in public speaking or whatever they want to do. So it's a much different lifestyle, a much different workload, and much different responsibility. And again, the Supreme Court, you're looking at providing that guidance on a much more national level. And you're also thinking about the future. Let's be honest, justices are humans. They're thinking about how can they make the mark on the law, and they might be looking for cases in which they can make that sort of dent in sort of legal doctrine and development.
Awesome. Talking about guidance, there's the rumor that basically, or the feeling that Supreme Court justices kind of just apply the policies of the president that appoints them. Do you guys see, and this is for discussion, do you consider Supreme Court justices as just politicians in robes pushing certain policies, or you see them as umpires, like completely unbiased, or something in between, or something else?
So I think if you ask them, they will tell you, no, we're not politicians. They will point to all of the many examples of where they rule against administrations of the party that appointed them, or even rule against the specific administration they appointed them. And I believe that every justice sincerely believes, no, I am not here to do the bidding of the president who appointed me or that president's political party. That said, the whole vetting process that administrations engage in to choose people to be Supreme Court justices is designed with one principal outcome in mind, and that is to choose someone who will predictably rule the way you want them to rule on the policy questions that matter most to you as the president. And so there have been counterexamples, right? The most notable counterexample is that David Souter was appointed by Republicans, and he turned out to be one of the more liberal members of the Supreme Court. And there is sort of a battle cry among the Heritage Foundation people that's like, not another Souter, they just really don't want that to ever happen again. And so these days, I think when you look at who's being named to the Supreme Court, I think you can predict that they will pretty reliably, in the close cases, right, the ones that are going to go off like 5-4 in the Supreme Court, be more closely aligned with the party that appointed them than with the other party, to the extent those two parties have different views about what the right answer should be about the law. Now, there's a bunch of questions where both major political parties are actually totally aligned. And there's a bunch of major questions where both parties are aligned and 9 justices think they're all wrong. And so, I think that there's scope for what I would call objectivity and real legal analysis. But the process is designed to produce a certain outcome. And I think they've gotten pretty good at producing those outcomes.
Yeah, so I would say that the ideal for a federal judge, including a Supreme Court justice, is to appear neutral, objective, dispassionate. And I think there's reasons for that. I think if folks feel that these are just politicians in robes, and this is something that Justice Breyer has written about and spoken about recently, that the credibility of the court is undermined, and he spells out a worst case scenario in which folks will just stop complying with what the Supreme Court hands down. So I do think there's this aspirational notion that we are objective and that we're just applying law to facts and we're just following these very standard modes of interpretation and doing so in a very neutral fashion. I think the reality is a lot muddier. And I remember a prominent constitutional law professor, Erwin Chemerinsky, saying to some of my students that you always have to remember that these are humans. So these are humans who are capable of error. These are humans who are capable of falling short of their ideals. These are humans who might be informed by their particular preferences, whether it's social or political, even though they may not admit it or want to admit it. And so I think it's up to us, whether it's lawyers, scholars, the general public, and others, to assess on an individual basis, on a case-by-case basis, do we really find persuasive the arguments that have been set forth? Has there been a good faith attempt to neutrally apply the law to the facts, or is there something perhaps else that justifies or explains this decision? And I think the importance of the Supreme Court, that they can strike down the actions of another branch and effectively set the outer bounds of what our society does. We can't do anything outside of the Constitution. They're the ones who have the final determination as to what that means. So what they're doing is vitally important, which means selecting a Supreme Court justice is important. And so we want, at least politicians want a sense of, who am I going to be appointing for life? And can I count on this person to support my agenda? I don't want to have to go through the process of setting forth this policy, like let's say the Affordable Care Act, and then all of a sudden the Supreme Court striking it down. And then we have to go back to the drawing board. So you want to have a sense that this person, and there's not going to be any explicit, ask, but you just want to get a sense for someone's record, their overall judicial philosophy, that this is someone who is by and large going to support our policy. And I will say, and this might be more cynical in nature, that there are a wide number of different ways to interpret the Constitution. I think there's agreement on what that universe of modes of constitutional interpretation are, but how you apply them is not always straightforward. And honestly, you could use any one of those modes to justify pretty much any outcome that you want, which is, I think, a reality, and it's also quite scary. So hopefully that's responsive.
We also have a question in the chat that I think is really important in our discussion, pertains to our discussion about agenda setting. So Arjun asked in the chat that with the departure of Justice Breyer and addition of Justice Jackson, if confirmed, how does that agenda for the court shift? And what kinds of cases would possibly start, what the Supreme Court starts seeing and taking on?
So it's a little bit hard to predict until you sort of see what actually shakes out in the process, right? One thing to note is that although they are very different people, Justice Jackson, if confirmed, and Justice Breyer are sort of on the same side of the ideological spectrum. And they're in the minority on the court. And so the idea that a new liberal justice would be doing a lot of agenda setting is unlikely, right? Especially the junior most justice on the court would be dictating a lot of what goes on. I think what will change is you might see some of Justice Breyer's priorities, start to become less salient. He's been, I think, really probably instrumental in getting the court to take an interest in some of the more thorny administrative law questions that it's taken up. That's a major area of interest for him. He's been writing a lot about the death penalty in sort of the last couple of years. I don't think it's going to really affect what mix of death penalty cases the court takes or doesn't take, because again, the liberal side is not setting the agenda on that question. There are some criminal justice issues where I think Justice Breyer is a little more conservative than some of his liberal colleagues. And so that may be a situation where actually a vote might change. Whether it means there are enough votes, to put together a majority for a criminal defendant on these questions remains to be seen. So I think it's very early to predict, but off the top of my head, I would say that what you might see is a little bit less emphasis on some of the administrative law questions, and maybe a slight shift in some of the other stuff, but it's too early to tell.
Yeah, I would agree with that. It's hard to predict. And as I was saying before, these are humans at the end of the day who have certain experiences and interests, and they're going to bring those to the table. And I think with Judge Jackson, she was a public defender. She has experience as a criminal defense lawyer. She also served for 4 years on the U.S. Sentencing Commission, which has been a subject of her confirmation hearings. For 30 years now, the Supreme Court has not taken up a pure federal sentencing guidelines issue. And some are of the view that Justice Breyer may be the reason why that's been the case. So you have someone who recently served on that agency who might be more inclined to say, let's take these cases up, and might be able to convince members of the court that we should not only take the case, but maybe pull together 5 votes to go her way. So I would anticipate, and I hope, that there's more federal sentencing cases that are heard by the court, but it's, again, impossible to tell at this point. And that's in large part due to the fact that Judge Jackson was sitting as an appeals court judge and as a trial court judge, where she had no choice over what she was hearing. Now she does have a choice. How she exercises that choice in concert with her other colleagues is really hard to tell.
I will add one thing about the process. So for those who don't know how the process works, when the court is deciding what cases to take up, they have all the petitions seeking review. And the first thing that happens is the Chief Justice prepares a list called the discuss list that gets sent around to all the other chambers. And the Chief Justice tries to put on the list any case that he's interested in discussing and any case that he thinks anyone else might be interested in discussing. Any case that doesn't make it onto the discuss list goes to what's informally called the dead list. That is, the petition will be denied without them talking about it at their conference. But when he sends the list out, it goes down the justices in order of seniority. So the most senior justice goes first, and he can add anything he wants to the discuss list. And then it keeps going down and down and down and down and down. So if you're the newest justice on the court and the discuss list gets to you and a case isn't on it, it means that none of your 8 colleagues is interested in talking about the case. And so unless you have kind of a lot of chutzpah, the chances of you being like, oh yeah, I'm adding this, are pretty low, because you already know that 8 other justices have taken a look and passed, right? And so I don't think that you'll see Justice Jackson doing a ton of agenda setting. The effect will be felt much more by Justice Breyer, who's now relatively senior, no longer being in one of the early spots to modify the list.
Awesome. Thank you, both of you. So I just want to keep us going so we can try and cover everything. So the next topic is really applying what we've talked about as issues that the justices are willing to consider, and talk about how that matters to the Sikh community. And maybe you guys can go over just some example cases that happened in the past, or some future issues that may come up that does affect our community.
Well, I think anyone who lives in the United States should care what happens at the Supreme Court. And I think as Sikhs, as Americans, everything that happens at the Supreme Court should be considered important because they, as I said before, they set the outer bounds of what we're allowed to do in our society. And so we have, members of our community who might have particular interests, and regardless of what they are, they're going to be informed by Supreme Court's decisions. That said, there are some issues that might be of greater importance. For example, civil rights. There was a case, a Title VII case. Title VII is a federal law dealing with employment discrimination. And so there have been cases that have come up before the court where you don't have a Sikh litigant, but the underlying principle and the decision of the court would nonetheless be helpful for future Sikh litigants. So there was a case dealing with employment discrimination filed by an applicant who was Muslim and wanted to work at Abercrombie and Fitch. And she went through her application interview, and the person who did the interview talked to a supervisor and said, well, I think this person is good enough to be on the floor. The supervisor became aware of the fact that the applicant wore religious attire and downgraded the applicant's score on that basis. And the applicant was then denied the position. The question that went up to the court was this a violation of Title VII, federal anti-discrimination law? And the Supreme Court said yes. And so that was not something that directly affected a Sikh applicant, but the principle nonetheless that this sort of action, downgrading someone's score simply based on religious appearance, nonetheless would be helpful for any future litigant and sends a signal, hopefully, to future employers. You can engage in this sort of action consistent with Title VII. So that's one example. There's another context dealing with religious freedom. So Congress has passed a couple statutes dealing with the exercise of religious freedom, the Religious Freedom Restoration Act, and then there's a corresponding one that deals with individuals who are incarcerated. And there was a case within the last 10 years dealing with a Muslim individual who was incarcerated and wanted to grow a beard of a certain length. And there was a state prison system that said, no, you can't do that because we have concerns about contraband being hidden in someone's beard. We have concerns about ease of identification. Let's say there's a fight or people are escaping. We need to be able to readily identify each and every individual in the prison. And so if you can shave and modify your appearance through a beard, you're undermining that interest. And so what the Supreme Court said, I believe it was the unanimous opinion decided on behalf of the Muslim individual who's incarcerated, providing, again, a robust meaning to that federal statute dealing with religious freedom. So I think there's a couple examples of where there's been decisions that have strengthened federal law in a way that provides greater protection to the community at large.
Ketanji, do you want to chime in on anything, or?
Nah, that's good.
All right, awesome. Sounds good. So I think you guys already talked about really, Ketanji, you talked about the KBJ versus Breyer, so Ketanji Brown Jackson. Can you give us just a little bit more background on Ketanji Brown Jackson, or Dave, if you want to do it, and just explain how it might affect the composition of the court a little more? You talked about it briefly, but if you could just give a little more detail where you think she'll go.
Sure. So, I mean, I'll start with sort of recent background. Judge Jackson is coming from the U.S. Court of Appeals for the D.C. Circuit, but she was only put there very, very recently in 2021 by the Biden administration, and really as a stepping stone to this job, I think. Prior to that, she was on the district court in D.C. for about 9 years. And that's where, or almost a decade actually. And so then you see the decisions that she issued there have become kind of talking points in in the hearings. You know, there were some decisions that involving criminal sentencing that the Republicans have been making hay out of in the hearings. There are other decisions against various administrations or for various interests that sort of people are talking about. But she has a record as a district court judge of about a decade's worth of rulings. And so, you know, I think that that is kind of where if you think about where her career has kind of really bloomed and where you've gotten to see the most of her thinking and what's probably going to be the best predictor of the kind of justice she is, I would look there. I would look to the district court decisions that she's been issuing, because as a district court judge, it's true she doesn't have the luxury to decide what cases come in front of her, but she does have the ability to decide those cases and decide them the way that she thinks is right. And so you see situations where she's issued decisions and given look inside her reasoning and how she approaches some of these weighty issues. And so, yeah, I think there's a fair amount to mine there in terms of, you know, understanding her as a judge and as a person.
Just to provide some, I guess, more biographical information, she, I believe, went to Harvard undergrad, Harvard Law School. She clerked for 3 different judges. She clerked for a federal district court judge, Patty Saris. She clerked at the federal appeals court level. And then she clerked for Justice Breyer, who she's now likely going to replace. I believe her career path after that was serving as a public defender. So if you have a criminal defendant who has no means of securing representation, she'd be an appointed lawyer for that criminal defendant. She also served, I believe, as a staff lawyer at the Federal Sentencing Commission. She worked at a highly respected law firm, Morrison and Forrester. And then she joined the district court. And you see some folks who are not too happy with Judge Jackson focusing on her district court record, particularly her sentencing decisions. I mean, if you have someone with most of their record is at the trial court, then they're going to laser focus on those decisions at that level, and particularly sentencing, which is, I would say, that the most difficult thing that any district court judge has to do is impose a sentence on an individual. And as I mentioned at the outset, Judge Jackson served for 4 years on the Federal Sentencing Commission as a commissioner, where she helped revise the sentencing guidelines, which are national norms. It's a thick manual that each and every federal judge has to consult before imposing a federal sentence. She was vice chair, I believe, at one point. The chair was Patty Saris, so there's some, familiar names in the process. Justice Breyer was one of the original commissioners. And then, so as was mentioned, Judge Jackson served briefly on the Federal Appeals Court, sitting in DC, which they say is the second most important court in the country. It deals with a lot of matters coming out of the executive agencies.
Awesome, thank you. So, and I'm going to actually tie in a question that we've gotten from the audience into this next section. So, wanted to just talk about the nomination process, and also as part of the process, of course, there's hearings. If you could also talk about what happened at the hearings last week, just to give a brief background to those that may not know. And I just want to pull up one question that kind of relates to this. Someone asked, could you explain your path to the Supreme Court? Is there any particular rules about your religion to serve on the Supreme Court? And what advice do you have for someone that is starting high school for a career in advocacy? So it's a bit of a mouthful there, but kind of tying those together is the nomination process. And if you want to, direct your path towards the Supreme Court, what should you do?
So make friends with the president is kind of the first agenda item you should put on your list, or position yourself to do that one day, I suppose. The nomination process, so just to give a thumbnail sketch of how it works. Step one is that the White House, in consultation with a variety of constituencies who have an interest, will sort of think about a list of potential nominees. And they will whittle that down to a short list that kind of ticks the boxes that they want out of a nominee. Then they'll go through a pretty intensive vetting process. The FBI will do background checks that are quite in depth and unearth pretty much everything. So if you're going into high school, here's another thing to think about. You probably want to burn down your social media at some point pretty soon. You pretty much don't want to say or do anything that will be on the internet forever. Or at least don't say anything dumb. Then after the vetting process is concluded, if they decide that someone is good, that the skeletons in their closet are manageable, that person will be nominated by the president. And then the process kicks from there into the Senate, which plays a role that's formally called advice and consent. And kind of feels a little bit different sometimes, but basically what the Senate gets to do is it gets to vote, and it takes a majority vote, 51 votes or 50-50 with the vice president breaking a tie, to confirm a Supreme Court justice to the seat. To get to the vote, the first thing that happens is that a committee on the Senate called the Senate Judiciary Committee holds hearings. And at those hearings, senators get to ask questions of the nominee. Those are the hearings that just happened, that we saw multiple days of questioning in. After that, the committee itself takes a vote to send the nominee to the floor. And on the floor, you need a majority of the senators to vote for confirmation for this to happen. Now, historically, the process has taken at least 3 months, but with Amy Coney Barrett's nomination, they did it in like a month. And I think the Democrats are targeting a similar timeline for this confirmation. They want to move as quickly as possible because they have a razor thin majority in the Senate. And so they really want the confirmation done before they lose it, either through somebody getting sick or through this whole thing getting dragged out and an election happening. And so that in a nutshell is what's going on. Now, as a formal matter, the purpose of the Senate Judiciary Committee hearings is for senators of both political parties to ask questions to the nominee, and for the nominee to answer the questions so that they can reveal what kind of judge they will be. Actually, what the hearings are for is for senators of both parties to make speeches about what they care about, and for the nominee to avoid answering as many questions as possible for as long as possible until time runs out. And that's because pretty much what every senator is going to do when it comes to a floor vote. And so there's very little reason to actually have a dialogue in these hearings right now. It's a somewhat cynical view of the confirmation process, but I think there's almost no doubt that at least since, since Elena Kagan came up, the model for nominees was say nothing, do nothing. Just rely on your political majority to get you through the process. And so I think as you look at what's going on, it's basically senators scoring political points and the nominees sitting through it as we all watch.
Yeah, just a few things to add. So I always tell students there's a 3-step process. You're nominated, so you're picked by the president. The Senate goes through its confirmation process. And then 3, if the Senate approves you, then you receive your appointment, which is actually like a signed document. And you might see Judge Jackson actually go through that signing process. My views on the confirmation process are similar. I think there's a lot of political grandstanding that the senators are not really speaking to the nominee, but really speaking to their constituents and trying to get some political points scored during the process. There was an op-ed written several years ago about the confirmation process and what the principles are that govern it, and a couple of highly experienced Supreme Court advocates said the only law is the law of the jungle. Pretty much anything goes, and I do think that's the case. I wanted to briefly just run through some of the questions that are here on the Q&A. Have hate crimes ever been addressed at the Supreme Court? There are a couple major cases dealing with hate crimes. One is dealing with hate speech. And then the court said that hate speech still constitutes protected speech. And then there was a subsequent case asking whether you could have a sentencing enhancement based on the fact that a person was selected because of a protected characteristic. And the Supreme Court said, yes, you can have a sentencing enhancement because a crime was motivated by someone's, let's say, race or religion. So what is the process to overturn a case? So the Supreme Court, one of the things I like to mention about the court is what I think is the mascot of the court. If you go to the court, there's a lot of symbolism throughout the building itself. And you'll notice that some of the pillars at the bottom, there's some turtles. And so I think that the turtle represents or serves as the mascot of the court. Why the turtle? Because it's slow and steady. It's not going to change course very rapidly, which is, I think, consistent with the general attitude or character of the court, which is once it says something, it's not going to quickly revisit that prior ruling, but there are circumstances, and I think some very positive ones, in which the court has said, you know what, we got it wrong. Brown v. Board is probably the best example of when the court said, you know what, we got it wrong, so we're going to change course, change direction. There's generally 4 considerations that the court will turn to when they are thinking about overturning a case. 1, have the facts since that past case changed? Are any underlying legal principles different from that past case? Have we announced a rule that is just impossible for lower courts to apply? So we've given something that's really unfeasible or unworkable. And then the last is like, what are the social reliance interests on that past rule? Has that past rule become embedded in our society that we would upset a lot of interests if we were to change course? So when it comes to Roe versus Wade or any other case that is up for reconsideration, that is at least nominally what the court should be considering, whether or not to change course. How does Gitmo play with the court? There hasn't been a recent Gitmo case that I'm aware of. There's been a line of cases, at least in the early 2000s, dealing with whether the Military Commissions Act was lawful or not, whether the whether the suspension clause applies to detainees at Guantanamo. So there have been some cases dealing with Gitmo, but I'm not aware of anything viable that might come to the court anytime soon. In terms of justices who were really interested in that, Justice Kennedy, who was very interested in that issue, who's no longer on the court. Justice Stevens, who was a veteran, who's no longer on the court. And so even if there was a viable issue, I'm not sure if there are justices who are interested. And do justices try to convince others of their view? Absolutely. The court is quite a secretive institution. When they're at their conference and going over the list of cases to decide, no one else is there, not even a law clerk, no secretaries, nobody else. But we know through records, when you have a justice who passes away, their notes are publicly available after a certain time. And so we've seen notes pass from justice to justice in which a justice might say, I'd be inclined to join that opinion if you change X, Y, or Z, or the initial vote was this, and it turned out to be after a discussion that. So yes, there's a number of drafts that'll go circulate amongst justices. What at one point was a majority opinion might turn out to be a dissenting opinion after there's been a full conversation amongst the justices. So yeah, absolutely. I mean, you think about it, if you had if there were 9 of you deciding, what to eat, you might vote for something, but you'd probably make an argument. I think we should get butter chicken for these reasons, and maybe people will go with you. So as with any human institution, there's going to be efforts to try and get people on your side of the table.
I would add one point on that, which is that a lot of people don't know this, but the justices do not tend to talk to each other about the cases prior to oral argument. And so oral argument is often the first chance that the justices get to interact not only with the advocates, but with each other about a case. And so a lot of what's going on at oral argument is not so much the justices really asking questions of the advocate, but it is the justices kind of bouncing ideas off of each other, using the advocate as the backboard, so to speak, for these shots they're taking. And so it can lead to a pretty entertaining experience as the advocate. You just sort of sit and watch the show as much as you participate.
Great, thank you guys. So I think that covers mostly everything I've done. Do we want to go through the last Q&A, or I have some follow-up questions if you want? Actually, let me go with one of the ones that I was actually curious in. There's been a lot of talk about expanding the court. Do you think there's a benefit to do so?
Maybe. I mean, it just kind of depends on what you want, you know? So if you expand the court, here's what happens. There's a few things that happen right away. The first is it will immediately be seen as exactly what it is, which is a political attempt to change the ideological valence of the court. Right? The reason you expand the court is you're unhappy with the composition of the current majority. You perceive that majority will endure for a long time without intervention, and so you decide to intervene. Right? If you do this, and you must be a Democrat if you do that, your story will be, well, remember what the Republicans did to Merrick Garland and how they wouldn't even give him a hearing and how they stonewalled and stole seats from President Obama. And so if we have the political power to do it, we're just going to do it, right? The problem with it is that I do think the credibility of the court takes a hit, right? Right now, there's a degree to which people pretend that the court is not just politics. And you know, the way I phrase that makes it kind of sound like I think it is just politics, and I think there is a lot of politics involved. But right now, the court as an institution has the credibility to weather that. And it is unclear whether an expanded court would maintain that credibility if it was really just, you know, all out in the open. If we no longer had the good grace to lie about it, you know, it might be a major institutional problem for the Supreme Court. Now, there's an argument to be made that, like, maybe that's not the worst thing in the world, that, you know, maybe the Supreme Court has too much power. Maybe it needs to be taken down a peg, and for both sides, right? One could make the argument, but it's a very complicated argument and not one that I'd be comfortable taking a side on or having a prediction about whether it would end up, you know, with a utopia or a civil war. I think they're both on the table. So, you know, my overall take on it is, I don't think it's a great idea, extremely risky. And there are probably better ways to get to good policy outcomes. And so, you know, I'm anti the proposition, but I understand where the impetus comes from.
I sort of share the same instincts. I understand the underlying motivations, but I do think that the credibility of the court would be jeopardized. And I do think that there's alternative proposals out there that could be a way to achieve a similar result without changing the size of the court. I will say, you know, the size of the court is not set in stone. It has changed over the years, not in recent history, but it has changed. You know, there's been proposals about changing. So right now, all federal judges serve for life. And the only way for a federal judge to be removed is if they resign or if they're impeached and removed. So that's the reason why we have life tenure, is to afford federal judges some degree of independence, that there's not going to be retaliation against a judge or a justice for a decision that the political branches don't like. And then the other measure of judicial independence is their pay can't go down. They can get raises, but they can't get pay cuts, which is odd. Now, there's some folks who say, well, instead of life tenure, why not have, you know, a generous term of 18 years or something of that sort, which seems to me, if you're really that concerned about the court itself, expanding it, I think, would be more of an extreme measure, and maybe term limits, something that more people could live with. And the more we know about sort of the ability of someone to be effective at later ages, might inform, hey, look, if you've served for 30, 40 years, maybe we don't have confidence in general that you'll be able to make that right call in terms of when you step down. So that could be a better way to achieve a sort of a similar interest.
Great, thank you so much. That was a great answer that I was looking for. So I think we're hitting the end right about now. So just wanted to thank both of you. Do you guys have any final comments you want to make before we close the session?
No, I'm good. This is fun. Thanks for having us.
Yeah. Awesome.
Yeah, and I just want to again thank SALDEF for organizing this event. I hope it was useful. I used to work at a law school and did law school admissions. So to the extent that anyone out there has an interest in pursuing a career in law or is getting their materials together for law school, I'm happy to serve as a resource in that process. Just I guess send a message to SALDEF and they'll get it to me. But I'm happy to be a resource to anyone in the community moving forward.
Yeah, absolutely. Thank you all for joining. Also, if anyone is in the DMV area, is in DC, oral arguments in the Supreme Court are open to the public. So if you happen to be there, or some are.
Not right now. They're still COVIDing. So
okay. So
maybe next term.
The next term. Traditionally, they have been, but not for COVID reasons. But if you are, interested, you can check one out. And also, if you are interested in engaging in the nomination process, you should go to our website and click our call to action. We're actually doing an email messaging service where you can email your senator and, just show your support for Judge Jackson. So definitely go to our website. It's also linked in the chat box here for our call to action. So definitely do that and email your senator in support of Judge Jackson. But thank you all so much for being here. Raj, do you have any closing remarks?
No, I think it was a great session. And I just wanted to thank Tejinder and Dave. I as an attorney learned stuff, so I think it was a great session for our community.
All right, thank you all. Thank you to our panelists, and thank you all for joining us.